A warm welcome to all participants and esteemed guests. Good evening, everyone. On behalf of IPNet North, I'm delighted to extend a heartfelt welcome to each one of you to today's webinar based on challenges faced by IPs while dealing with statutory authorities and enforcement agencies. As many of you know, this webinar is part of a series organized periodically under the auspices of IPNet, the National Network for Insolvency Professionals. Without much ado, I now have the privilege of inviting IP Mrs. Pooja Bari, Director of IPNet North Region, to deliver the formal welcome address. Over to Pooja.
Good evening, everyone. It is my pleasure to welcome you all today to today's webinar on the challenges which are being faced by insolvency professionals dealing with the statutory authorities and enforcement agencies. We are incredibly fortunate to have a distinguished panel of guests and speakers who will help make this session both insightful and thought-provoking. First, I'd like to extend a special welcome to our chief guest, Dr. Alok Shirvastav, former technical member, NCLAT. Sir, your presence today has truly elevated this event, and we are eager to learn from your vast experience and insights. We are also thrilled to have IP Mr. Vikram Kumar and CA Mr. Sachin Agarwal as our esteemed lead speakers. And a heartfelt thank goes to Shri Ashish Makhija ji, the president of the IPNet, whose leadership and vision continue to propel this platform forward. Now, IPNet has quickly evolved into a cornerstone for insolvency professionals across India. It has become much more than a network. It's a vibrant community where professionals come together to exchange knowledge, tackle challenges, and grow in their careers. Here at IPNet, we are committed to meeting the critical needs of the insolvency professionals, including continuous learning to expand your expertise, also timely, reliable advice on matters relating to the Insolvency and Bankruptcy Code, and it's a powerful forum to voice concerns and find practical, actionable solutions. Now, in response to these needs, the IPNet offers several standout features like a specialized study groups that engage in ongoing knowledge sharing. Then there are webinars and discussions on the latest industry developments and a dedicated member portal providing an easy access to resources that address all your professional needs in one place. Now further on, so please, Ma'am Tina, to introduce our chief
I
guest.
now request IP Tina. Thank you, Pooja ji. I now request IP Tina to introduce our chief guest, Dr. Alok Shrivastava, former technical member and CLAT.
Thank you, Sandeep ji. I welcome Dr. Alok Srivastav ji. Dr. Alok Srivastav, formal Honorable Technical Member of NCLET. Dr. Alok Srivastav joined IS in MP Cadre in 1984. He graduated in Electrical Engineering from IIT Kanpur in 1984. He was awarded a Master's in Public Policy from University of Maryland, College Park, USA in 1997. He also has acquired PhD in Economics from Jamia Millia Islamia, New Delhi, and PG Diploma in Public Administration from Punjab University. Dr. Srivastav worked as Union Law Secretary and Secretary, Department of Justice before joining of NCLET. He has extensive experience of working in infrastructure sector, including shipping, renewable energy, housing, and urban development. He was closely involved with development of wind and biomass energy policy in India and played an important role in policy formulation relating to blending of bioethanol in petrol and diesel. He was official director on the board of Indian Renewable Energy Development Agency. Development of green energy corridors has been another of his achievements. His work in the development of Chabahar port in Iran and towards formulation of Sagarmala project has been widely appreciated. He is credited with the establishment of Madhya Pradesh Jal Nigam. Schemes of access to justice such as tele-law and Nyay Bandhu for pro bono lawyers have been strengthened and expanded under his charge and have received acclaim in India and abroad. Welcome, sir. Welcome.
Okay, I now request, thank you, Tina. I now request Mr. Parag Singhal to basically introduce IPNet through videos.
Yeah, thank you. fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you, Pragji. So this was actually IPNet website. This is an interactive website. And now I would request our chief guest, Dr. Alok Shrivastava, to provide his insights on the topic, today's topic, which is challenges faced by IPs while dealing with statutory authorities and enforcement agencies through his keynote address. Over to you, sir.
So thank you very much, Mr. Chitkara, and thank you, Mr. Singhal, General Secretary of IPNet, distinguished speakers who are sharing the podium with me, Shri Vikram Kumar and Shri Sachin. I can see a number of insolvency professionals who are joined in this webinar, and it's my good fortune to be with you all here. So I had a short discussion. In fact, I was sharing a teaching class with Dr. Makhija just last week when he said that you have something like this. When we used to sit in the court, you were on the other side, even though we all, I think, in this insolvency process were stakeholders. So as members in tribunal, we never thought that we were different from what the resolution professional was doing or what the other stakeholders were charged with. But yes, we had to sit in judgment over a number of things that resolution professionals were doing or the other stakeholders. This is a new experience for me, and let me also share, Tina ji has given a very generous background of my career. I chanced into law just out of providence. So I have no background, and let me confess this right in the very beginning. I'm neither a law graduate, nor do I have any great background, but it was purely by chance that I became law secretary in Government of India. So in case there are any deficiencies in what I tell you, or there are, say, even wrong notions, please excuse me and pardon me. I haven't worked as an insolvency professional. I haven't worked as a resolution professional. And my experience of this is just about 4 years. So I'll try to give you some sort of a snapshot of how this space of insolvency professionals is evolving in the country and how it is being perceived. It's very important for us to know this is a very important network of IP professionals. And so I think it is also important for us to know how we are perceived in this entire process of insolvency resolution. So from the topic of this webinar, I understand that you are discussing statutory guidelines and enforcement guidelines and how the IPs are impacted by these authorities. While in general, an insolvency professional is not impacted by statutory authorities, but when they work as resolution professionals, then they are. So my presumption is that what you are perhaps looking at is that how are resolution professionals impacted by statutory authorities and enforcement authorities. Am I right, Chitkara Saab?
I have to unmute myself. Yes. Yes, sir. Thing is that we just want some practical insight from your side. So the difficulties faced by the IPs while dealing with the statutory authorities and enforcement agencies. So there have been various jurisprudence regarding the same. So I would like to have your insights on the same.
All right. So thank you. So let me first start, in a very broad manner by, how the IPs are born or how they come into this world. And they owe their existence to the IBC, which we all know. And the only thing that I can find of some substance for IPs is the code of conduct, which to me is like a Bible for the IPs. And while it's just a code of conduct, so it doesn't have a great legal backing. Of course, it has, but there is no articulation of what that code should be. I mean, when we say uh, the IPs should have integrity, that only means that they should have integrity, but there is no scale or no parameter to really check integrity. Uh, Same thing about objectivity, independence, impartiality, professional competence. Now, these are all very, very subjective parameters. But I think when you talk about all this and when you discuss this in professional fora, uh, you would certainly see that what is professional competence? I mean, how do you gain? And it's an ongoing thing. So you can start, let's say, on a scale of 10 at about 3 or 4 and go up to 7, 8, and even more. So for IPs, the code of conduct, as I said, is the Bible. So look at it very closely. But if you were to ask me what is an IP and why should an IP, what are the basic characteristics that an IP should possess, I would say only two things. The first is knowledge and understanding about the ambit under which an IP functions, and also when an IP becomes a resolution professional, what are the guidance, what are the guidelines, what are the rules and regulations that an RP will have to function within. So knowledge is of course one. Again, knowledge is an evolving thing. IPNet is a very good platform where you exchange ideas, where you get to see. Perhaps, it appears like a one-way platform more, even though there would be interactions also in between. I have some ideas which later on I could discuss with Dr. Makhija about how to make it a little more interactive. Because you have such a wonderful, I mean, I believe there are about 800 members in this network. So if it is a two-way street, then the IPs would on almost like a daily basis would have access. And I worked for a few years with United Nations Development Program, where we ran communities of practice, where practitioners who form a community could exchange ideas in a very interactive manner. So that said, I mean, that's something that I'll discuss with Dr. Makhija later, how to make a little more interactive a platform like this, which is such a valuable thing. I mean, 800 members is not a joke from all over the country. So moving on, and insolvency professional, I think the greatest statutory body that it has to face or they have to face is the IBBI. And it's good to know, and there are complaints, there is inspection, there is investigation. All those provisions are there in the regulations, which you may be aware of. But just for the sake of completeness, I'll only say that there is the IBBI Insolvency Professional Regulations of 2016. Please go through this. This is very important. And the regulations, I think, most importantly, talk about disciplinary action. And as a member in, we had also often we came across cases and instances where the resolution professionals were, for reasons best known to them, were found short of performing their duties. Giving everyone the benefit of doubt, there were cases where it was very clear that there was some kind of a mixed up uh, conduct, but perhaps also at times it was lack of complete knowledge and understanding about how an insolvency professional, when he comes in the field as a resolution professional, should conduct himself. I'll just take a couple of minutes to talk about the pitfalls as we saw. And often what happens is I've worked a lot in the urban sector in urban development, and as members in tribunal, we had to handle cases related to real estate, where my own impression was that many RPs were not really up to the job. So they did not know how to handle real estate, but they became a resolution professional, and then they were running scared because with 100, 200 home allottees running after the resolution professional, the RP wasn't in a position to face them. But in addition to this, one was of course the inability to face the home allottees. But in addition to that, there was also this problem that they did not know how to move ahead. I mean, how to bring matters to a decision point and take decisions. And but there was another class which, even at the expense of being a little unpleasant, I would say, who seemed to be mixed up with the past promoters of the real estate company. Now, these are very sensitive, very delicate issues, whether it is about lack of knowledge and understanding or lack of maybe full integrity in the matter. I would only flag these and leave it to the IPs to decide when they become RPs as to how they would conduct themselves, whether it is about competence, whether it is about integrity, whether it is about honesty, whether it is about objectivity, natural justice, having all the stakeholders together and treating them all on the same plane or at the same level. So that said, there's one thing that I have often thought about, and let me share that with you also. Uh, Now, a resolution professional's job is a really challenging job. And I recall my days about 35 years ago when I became district collector the first time. We were very young, and most of the IPs, I would say, are young in terms of experience, if not of age, but I was hardly about 28, 29 years old when I became a district collector. And the whole canvas and the range of issues that one had to encounter, one had to really face and find solutions to were huge, and there was nobody to guide you. I mean, as a district collector, you did not feel strong enough and you did not feel brave enough to go to people and say that, I haven't learned this, I don't know how to tackle this. And in the field, there weren't many seniors who were there to guide you or make things clear to you. So one of the problems that we faced, and later on as we progressed in our career, was that we all found our niche areas where we would gain experience and we would become a little more sound, both in terms of professional competence, knowledge, understanding. So one of the things that I discovered, and I would put it across to all the insolvency professionals who are part of this webinar, is that you will very soon be able to understand whether I am good enough as a resolution professional of a manufacturing company, whether I'm good enough as a resolution professional of a real estate company or maybe an IT company, a knowledge-based company. And this is something that perhaps the IBBI could take lead in, because now you classify them, and when the appointment takes place, you pick up a good resolution professional in case a name has not been suggested, or an operational creditor has filed an application for admission. So you will have a little more knowledge going by the background of those insolvency professionals, so that you will have an idea about where to put him. I mean, this is not just a job. And an RP's job is not just a job where you get placed and then you learn on the job. I mean, the RP has to really hit the ground running. So the moment you start, the day one is like, your clock is ticking. People are looking at you. People have interests. They have a lot of self-interests when they come in the COC or even otherwise, and they are all gunning for you, and they are all wanting to put you in a spot. So you have to be very, very careful about how you handle and how you come across as a professional. So that's one of the experiences that I found, that if you select your niche area and you know that, yes, I will specialize in 1, 2, 3 areas, and perhaps when a chance comes, I'll be able to handle a company of this kind or of this type. That might help, or that will also bring, because right now everyone is kind of vying for every company. Now then you will have niche, and I look at it like this, that if there is a case which has a technical or technology behind it. I mean, I'm just recounting what I encountered when along with Honorable Chairperson in the NCLAT, we heard the Google case, the Competition Commission judgment and the appeal thereon. I was, being an engineer with some background, I could certainly appreciate the subject matter much more, because now things are very intricate, and when you look at competition law, it's not merely the law, but what so is behind the law, what is the technology, what is the economics. So your niche area, given your background, where you come from, what kind of educational qualification you have acquired, perhaps would help you decide on what kind of niche area you would, and then you will shine. I mean, you are going to be doing very well. So in general, I just wanted to talk about the IPs, and how the code of conduct operates for them. We have had occasion I mean, I was personally responsible for imposing a huge penalty. So, I'm also in some ways guilty, and perhaps not the best person to be sitting here. In a case, we impose a penalty of 50 lakhs on the resolution professional and 50 lakhs on the promoters. So that's perhaps the highest penalty. And I did implore the chairman of IBBI also to look at some exemplary cases and also impose some exemplary punishment also. And perhaps IBBI is now set on that. But that is something that will separate the grain from the chaff within the IP community. We should not hate it. It's a corrective measure. But if and every profession will have people who are bad apples or maybe black sheep. It's a good idea to keep on sifting through the overall material that you have, so that the world at large, and at least the space that we all function in, know those people know who are the ones who would be good resolution professionals, who would not.
So may I ask
I
something?
Yes.
May I ask something?
Yes, sir.
Sir, these are actually the beautiful insights which have been shared by you. But this is all about code of conduct to be followed by the IPs as resolution professionals. So I would request for some kind of insights, since you have a very good experience. So I would like you to share some insights regarding the role of or the understanding of IBC mechanism by the statutory authorities. So like they submit their claims very late. They do not understand about the IBC mechanism. They take control of the assets and do not release those very assets. And maybe similar is the case about the enforcement agencies. So wherein jurisprudence is there, and they always take hold of the assets and do not release those very assets in time, and create hindrances in the process for the resolution professionals or the liquidators to work. So maybe some kind of insights
Oh,
about
certainly. I know that was
these very
actually the
aspects.
other part. I just quickly wanted to get over the IP part, the code of conduct, because I would say that is the Bible. But you very rightly said, and I would spend much more time about the pitfalls that the resolution professionals face, and how they are. I mean, they are actually caged and fenced from all sides. So there is the COC, which is looking at them with hawk eyes, but there are other stakeholders, and you very rightly mentioned. So let me start now, switch over from insolvency professional to resolution professional. So, Mr. Chitkara, I was a little confused because I thought that if you're going to talk about just insolvency professionals, then in general, an insolvency professional does not face the kind of statutory issues or enforcement issues that a resolution professional. So I'm just trying to
Yes,
separate.
certainly.
IP is a much larger set, and RP among them is a smaller subset. So now shifting from the larger set to the smaller subset, that is resolution professionals. Uh, the day the appointment of the resolution professional takes place, the clock really starts ticking, in the sense the timelines kick in and everybody is keen, at least the creditors are keen, that the resolution professional is brought to a good fruition. But the resolution and some resolution professionals are up to the job, so they do the job very well. Some are not, and so eventually what happens is that the company goes completely down the drain. While it is already in doldrums, it goes down the drain, and liquidation is the only answer then you get. And there is criticism about that also, but I leave that. Now, what are the problems that the RP faces? I mean, the first problem is you issue a public announcement, and after you issue the public announcement, you invite claims. Now the claims are, but now of course the IBC, there are lots of amendments, so the claims can be submitted till very late stage in the insolvency process. So Mr. Chitkara, I would not want to go into any great detail about what those amendments are, but I can only say this, that courts have, as the jurisprudence has developed, courts have been pretty generous and liberal in dealing with claimants, particularly claimants in real estate companies.
Okay,
And we all know this, that people who are home allottees in real estate projects, many of them have put their lifetime earnings. The RP goes really by the book, and there is no harm in doing that. I mean, even when we have had cases, I have also been a little liberal when I sat on the bench vis-a-vis the real estate allottees. But I can only say this, that if the RP is playing by the book, which is what the rule says, you cannot fault the RP. I mean, the bench might still say that, look, this man unfortunately was abroad, could not file the claim in time, and now there are many opportunities given to the claimants to file their claims till very late stage, till almost the time when a resolution plan is to be discussed in the COC meeting. So in claims, my understanding and my advice would be that go by the book. I mean, if you have a 14-day time limit that is given there, and proof has to be given, then you stick by whatever timelines have been put, so that everybody is then treated on the same plane. You don't start exercising the judgment of who you should admit and who you should not admit based on timelines. I mean, if somebody has not submitted his or her claim in time, the best you can do is, let him approach the NCLT and obtain an order. And if he gets an order and the RP thinks that that is perhaps the only case of its kind, it may not be a bad idea to admit such a claim. if the NCLT. But if you think there are hundreds of such claims and the floodgates would open, perhaps the IP will have to then also appear before the NCLT to fight it out. But that said, eventually it will be the tribunal and perhaps the appellate tribunal where you will fight it out, and then you'll have to abide by whatever decision is arrived at finally. But my advice here would be that be very clear about what you're doing. And if you don't have access to good accounts people, try to get one at that stage, because often when you look at the papers that are submitted, the documents that are submitted by way of proof of claims, sitting alone, it becomes a little difficult to decide. So I'm sure you have now access and support of people who know the accounts, who can look through the papers. And whatever, I mean, importantly, wherever you are admitting a very, very confusing kind of claim, perhaps put your papers in order so that in case a case comes up later, you are able to defend. Or if you are rejecting a claim, I mean, what happens normally is that if the claim is there, and even government bodies will fight it out sometimes to no end, and they know that they are not going to win also, but the discoms and there are tax authorities who will fight it out till the very end. You have to face it. What I have discovered is that, you see, RPs of course lose a precious amount of time while they are facing these cases. This is very challenging. They have to continue running the CIRP during this period, but so you have to have a couple of people who are there to understand, and very quickly you'll have to put them in place so that they can take care of the legal issues that arise. Because on legality, what do I say? I mean, I would not like to say anything about the members in general, but I will only say this, that every member does not share the same kind of temperament, and every member does not come with the same kind of background. So you have to factor that in. And often you will find that I have gone by the book. I have followed the rules to the T, and so, look, what the court is saying. But that's.
So may I interrupt here? So
Yes,
actually, there is a lot to learn and a lot to listen from you. But sir, my request is that we are short of time, and I would like you, sir, to maybe sum it up if possible.
Yeah, I'll sum it up. So now coming to the enforcement agencies and the statutory agencies, I would say primarily there are four. One is, of course, the Enforcement Directorate. Now the jurisprudence is more or less clear on that, if it's just a civil liability, then IBC will take precedence. The tax authorities, we are very clear that once the moratorium is imposed, then there is nothing that you can do. The tax authorities will have to file their claims as everybody else and wait for the resolution. And then there are cases like embassy property development and Gujarat Urja. So that there are now specific, I mean, if there is a contract, there's an agreement, there are specific acts and laws under which those agreements are. The RP should not exceed whatever limits are there for his functioning during the moratorium period. So let me then sum up by saying that the challenges are too many. Some of the challenges will have to be dealt with in the light of the jurisprudence that has existed or has now appeared or evolved. Some of them you will have to probably take recourse to Section 14 and the moratorium and brush those aside. Taking possession is a tricky thing. I think it will be on a case-to-case basis. I would not say that there is a one-size-fits-all for that. I'll stop here because I know there'll be many more ideas that will be coming. Thank you so much for listening to me very patiently. And I'll be with you, Mr. Chitkara, for about half an hour more. And
Yes,
I had another engagement at about 5:15. So I'll beg leave of you around 5:15. I hope that would be all right.
So we would like you to stay here. And as I said earlier, So there is a lot to learn and listen from you. And I would now request Mr. Parag to express maybe vote of thanks to our chief guest
Thank you, Sandeep
and
ji.
present him a memento.
Yeah, sure. Thank you, Sandeep ji. On behalf of IPNet, I extend my sincere gratitude to Dr. Alok Srivastava sir for sharing his insights and knowledge on the subject and taking out time for the webinar. So please allow me to present a memento as token of appreciation. And this memento will be delivered physically to your office, sir.
Thank you very much, Singh.
Just a moment, sir.
Lots of thanks to you, sir.
So this will be, sir, delivered to you physically also, sir.
Thank you so much. Thank you.
Thank you very much, sir. Chitkara, sir.
Yes, I would now request our IP member, Mr. Jalesh Grover, to introduce our lead speaker, IP Vikram Kumar. Is he there?
Yeah, I am here,
Yes,
sir.
sir. Yes, sir. Please introduce Mr. Vikram Kumar.
Yeah. Good evening, everyone. Thank you, Chitkaraji. So it is my privilege to introduce Mr. Vikram Kumar. He is a fellow member of the Institute of Chartered Accountants of India with over 30 years of experience with CISA USA, CMA Australia, DISA India, member Institute of Social Auditors of India, ISAI, and a qualified independent director accreditation. He also has successfully 121 assignments as an IRP, RP liquidator under IBC. Mr. Vikram is a regular speaker at the Staff Training Center for various public sector banks and financial institutions. He is also a speaker at educational institutions like Indian Institute of Insolvency Professionals of ICAI, ICSI Institute of Insolvency Professional, Institute of Corporate Affairs, National University, Delhi, and the Insolvency Professional Agency of Institute of Cost Accountants of India. Mr. Vikram has delivered more than 100 lectures on various topics under IBC. He has contributed several articles to various journals on IBC published by the IPA of ICAI, ICSI, and Institute of Cost Accountants of India. He is also empaneled as an insolvency professional with most of the public and private sector banks, ARCs, and financial institutions. So over to you, sir.
Yes, Mr. Vikram.
Yeah, thank you very much. Thank you, Jalesh ji, for all the introduction. So, quickly I will just upload my presentation. So, if you just confirm that the presentation is visible in full screen.
Yes,
sir.
Very much visible, Vikramji.
Okay, thank you very much. So, we are going to discuss today a very important topic, which I think is very, very close to most of the insolvency professionals. The challenges faced by the insolvency professionals with statutory authorities and enforcement agencies. So I'm sure every practicing insolvency professional has had a fair share of challenges faced with the statutory authorities and enforcement agencies. So first and foremost, let us see on the screen that every IP has to deal with a plethora of enforcement agencies and statutory authorities. So we have to deal with CBI, Enforcement Directorate, EPF, EOW, GST, Income Tax, Customs, ROC, SFIO. So these are some of the authorities with which an IP has to deal while delegating his duties as an IRP, RP, or a liquidator. Now let us see what are the primary challenges faced by an IP while dealing with the statutory authorities. So on this screen, I have tried to capture the major issues faced by the IPs dealing in any assignment. So let me point out the pointer here. So the primary problem which most of the IPs face is non-filing of the claims by the statutory authorities, or delayed filing of the claims, or multiple claims filed by the statutory authorities. That is one of the significant challenges faced. Now, we are also aware that after the claim of financial creditors, I think the claim from statutory authorities is the most significant amount of claim which we come across. And if they don't file the claims in time, then the whole process can be put to a lot of challenges. Second is the lack of understanding of the code by the statutory authorities is the second issue. Third is blatant violation of the moratorium provisions by the statutory authorities. Now, attachment of bank accounts by income tax department is very common during CIRP process, even though it violates the moratorium, but they are not budging from releasing the bank accounts attached. Seizure of records by CBI is another challenge. Legal actions being taken against the RPs and IRPs is also very common. They are now considered as the officer in default. So they fail to distinguish an insolvency professional from the promoters of the company. So once an IP is in charge, he is considered as an officer in default. Now, we are all aware about the important judgment of Rainbow Paper, which led to, the dispute whether a statutory authority is a secured creditor or an unsecured creditor. So these are some of the challenges which is very commonly faced by every IP. Now, lack of cooperation is very, very common because the statutory authorities, they don't, give much weightage to the IPs, and, you don't get the desired cooperation from these statutory authorities. Summons are issued to the IPs. Ideally, the summons should have been issued only to the directors and promoters of the company, but it is very commonly seen that once an IRP or RP takes over as a company, he is issued summons for personal appearances by the ED and CBI. Now, not respecting the timelines laid down under the code is the other challenge. Inconsistency between the various laws and IBC code is, the other issues which we face. Now, statutory authorities do not forego the lien charged on the assets of the company during CIRP process. So these are some of the issues which I am basically highlighting, which we face during the CIRP process or any process under the code. So on this slide, I have tried to, pinpoint some of the solutions which, can address the challenges faced by the IPs. So regular training, I think, is the most important solution, that the statutory authorities and EDs must be regularly trained on IBC matters. Because if you don't train them, then naturally we would have difficulties in dealing with the statutory authorities. So regular training is an important solution for these authorities. Second is that if we can have a nodal officer with every department at major locations, so and these nodal officers are trained officers under the IBC, so what happens, any issue which crops up, the IRP or the RP can interact with the nodal officers who are experts in IBC matters because they are trained, and they in turn can act as a bridge between the statutory authorities and the RP. So having a nodal officer could be very helpful. Serving a copy of the admission order directly by the NCLT to the statutory authorities could be the other solution, so that they come to know that a process has begun and they have to file a claim. So it is always advisable that the admission order is sent by the NCLT directly to these statutory authorities. Sensitizing the statutory authorities on the timelines under the IBC code. Sensitizing them that IP is an officer of the court. He is not the director of the company, so he has to be treated with more respect. And a very important, solution could be that, as we are all aware, that, in the code it says that the powers of the board is suspended. But if a line is added to that section as a proviso that the duties of the directors are not suspended, rather the duties of the directors are compounded, if this line is added, I can assure you that the life of IPs will be much more comfortable. Because what is happening, the moment a company goes into CIRP, the directors are able to convince the statutory authorities that their powers are suspended. Now they cannot do any activity. And the statutory authorities believe that now the directors are powerless. But actually the fact of the matter is, their powers are only suspended. The duties are not suspended. Their duties are actually compounded during the CIRP process. But this message has somehow not reached the statutory authorities, and as a result of which we are put to a lot of challenges. So duties of the director is not suspended is something I think must be added to the IBC code. The message has to go loud and clear that if there is an inconsistency between the IBC code and the various statutes, then IBC will prevail. And post the judgment of the Supreme Court in the matter of Paschimachal Vidyut Vitran Nigam Limited, I understand that a message can go to the government authorities that the government dues are unsecured dues and they are not secured dues. That can reduce a lot of litigations. Then I think IBBI need to take steps to educate the statutory authorities and advising them that summons should not be issued to the IP, summons should only be issued to the promoters. So these are some of the solutions which we have suggested here. So basically, I will sum up the solution as threefold. Number one, we can have some standard operating procedures wherein the IP and the various statutory authorities can be on the same page. So for example, government dues is an unsecured dues. If suppose this message can go to the authorities, then a lot of litigations can be avoided. Number two, regular training by IBBI and IPS could also be very, very useful. And lastly, if guidelines can be issued by IBBI to the statutory authorities based on important judicial pronouncements of Supreme Court, wherein some matters have been settled by the Honorable Supreme Court, then we need not litigate on those issues which have been now settled by an order of the Supreme Court. So these are some of the prescriptions whereby we can reduce litigations specifically while dealing with statutory authorities. Now what I have done, I don't know how much time we have, but I have tried to cover specific areas of dispute or challenges with respect to PMLA, EPF Act and Income Tax Act, because the major challenges faced by an IP is either with respect to the EPF Act or with respect to income tax or PMLA. So I have separate slides on these three topics. So what I would do, I would cover the provisions pertaining to EPF, and I would pause, and then I will pause, and I would request my co-speaker Sachin to come in. If time permits, then I can go to the next topic if possible.
Vikramji, you have 15 minutes.
Okay, so I will try to wrap up the EPF Act in 15 minutes, and I'll hand over the mic to my co-colleague Sachin. Okay, so what are the issues faced by IP with respect to EPF Act? So the major challenge comes from the provisions of Section 36 subclause 4. As we are all aware, Section 36 talks about the liquidation estate, and 36(4) says that following shall not be included in the liquidation estate assets. So certain assets are not included in the liquidation estate asset. That is what is Section 36 subclause 4. Now our particular interest is 36 subclause 4 subclause 3, which says all sums due to any workmen and employees from the Provident Fund, Pension Fund and Gratuity Fund. So what is important to note here is that only the assets are excluded and liabilities are not excluded, because in the liquidation estate asset, we are trying to exclude certain assets. Now, if we have a fund like a provident fund or a gratuity fund or a pension fund, then that has to be excluded. It has to be exclusively used for payment of dues to the employees. Now, we all know as accountants how a fund is created. So whenever a fund is created, we have a liability, and the amount liability is matched by an equal amount of investment, usually in government securities. So unfortunately, what has happened is in a lot of CIRP cases, we do not have any fund. Only the liabilities are existing. But if you see most of the orders pronounced by the Supreme Court or the NCLTs or NCLTs, these liabilities are being thrust on the SRAs, and the SRAs are being asked to pay the entire dues pertaining to EPF as on the insolvency commencement date. So the disconnect here is that only the asset has to be excluded. Now, if you do not have a fund, you only have the EPF liabilities, then how do you exclude these liabilities basically? But unfortunately, if you see, the courts are asking the SRAs, like in the case of Jet Airways or in the Mozambique, if you remember, the courts have been very, very categorical that the SRA has to pay the entire dues as on the insolvency commencement date. He has to pay the entire dues. So that is an additional burden on the SRA. Now, the decisions of the courts are contrary to the clean slate principle as pronounced by the Honorable Supreme Court in Ghanshyam Mishra's case. So that is a major challenge which every RPs are facing. So if suppose you are the RP, you do not get a claim from the EPF department, you have approved a resolution plan. After the plan has been approved, you get a claim from the EPF department, and now the SRA is into a big problem whether he implements the plan or he first pays the dues to the EPF department, which has not been accounted for in the resolution plan. That is the problem I'm trying to highlight here. And the problem here actually, is what I have explained. Now, to understand this problem, we need to understand two important provisions of the EPF Act, and that will help us to understand what is the genesis of this problem and why the courts are asking the SRAs to pay the entire dues. So let us see Section 11 of the EPF Act. Section 11 says priority of payment of contributions towards EPF over other debts. That is Section 11. Now, Section 11(1) says that where an employer is adjudicated as an insolvent or an order of winding up is made against the employer, then the dues of the employer, whether it is towards the employee's contribution or the employee's contribution towards EPF, contribution towards damages, or any accumulations, is to be paid in priority to all the other debts. That is Section 11(1). So payment of EPF dues is in priority to all the other debts is Section 11(1). And 11(2) is even more important. 11(2) says that the dues of EPF is a first charge on the assets of the establishment. Now, what is very, very important to understand is 11(2) have an overriding effect on the IBC code, or will IBC have an overriding effect on 11(2)? That is the issue which most of the RPs are committing mistake. Now we have an order of Supreme Court which is very, very categorically saying that 11(2) will override IBC code. IBC will not override 11(2). So
Vikramji, this is Ghanshyam Das Mishra?
No, this is not Ghanshyam Das Mishra. I'll just come to that judgment because we have very limited time, but I'll try to cover this provision. So what I'm trying to say that as insolvency professionals, we usually believe that IBC will override all the other acts, but there are exceptions to it. And one of the exceptions is 11(2) will override IBC code. So let us understand one more section of the EPF Act, which is Section 17B. Now what 17B says, liability in the case of transfer of establishment. Now what is this section? This says where there is a transfer of establishment by an employer to another employer, then the earlier employer and the new employer are jointly and severally liable for the dues of the EPF. Now, when you transfer a company under IBC through a CIRP process, does it tantamount to a transfer or not? That is the other issue which we have to understand. And unfortunately, or fortunately, how you take it, the transfer under IBC through a CIRP process is also considered as a transfer. So we have a judgment to that effect also. So the nutshell is, because the transfer from the CD to a new SRA is a transfer, and the liability of the CD now vests in the SRA. So that is the reason why the courts are asking the SRAs to pay the entire dues as on the CIRP date Now, we as insolvency professionals find it very difficult to understand because we believe the clean slate principle. But there are provisions beyond the clean slate principle. So 11.2 and 17B are the important provisions of the EPF Act to understand the genesis why the Supreme Court or the other courts are asking the SRS to pay the entire dues as on the insolvency commencement date. So let us see one very important judgment which will answer most of the queries. Now, this is the judgment of a Supreme Court in the matter of SK Pharmaceuticals. So this is an old judgment prior to IBC, but very, very relevant to us because this case pertains to the Companies Act 1956, Section 529A, which was introduced in the year 1985, this 529A. Now, 529A is very similar to Section 53 of the IBC Code. So for us to understand here, the similar issue arose and Supreme Court said, just because 529A is a latter, legislation, but it will not override 11.2. So IBC code is also a latter legislation. So with similar interpretation, EPF Act will override the IBC code and not vice versa. That is the first problem. The second is, if you see section 53, it says pari passu charge. Under 53(1)B, it says pari passu charge between the employee dues and secured creditor. It is not first charge. 11.2 talks about first charge. And first charge will always have a first right of payment. So that is the other issue we have to understand, that 53 will come into play only when the dues of EPF have been completely paid. Other dues of employees will be covered under 53. So EPF is outside section 53. So in nutshell, what is very important is that EPF dues is a huge sticking point for every insolvency professionals because the EPF department does not file their claim in time and we are not aware what is the claim. We find it extremely difficult to, calculate or estimate what is their claim. And ultimately what happens, the EPF department comes into the play when a resolution plan has already been approved by the COC pending application with the NCLT. And the whole process for CIRP can go for a toss because the claim of EPF has not been properly adjudicated during the process of CIRP. That is the point, I'm actually highlighting. So the concluding remarks, with respect to EPF, because this is an extremely important issue, the courts have also taken a stand that if you have not paid the dues of EPF, then your plan is not compliant in terms of section 30, subclause 2, subclause E, which says that the plant has to be compliant with all the laws of the land. So that is the other issues which RPs are facing, that courts are saying, since you have not paid the EPF dues, your plan is itself not compliant with section 30, subclause 2.
But Vikramji, so I would so interrupt here. So
Yeah.
let us say in a case where the claim of EPFO, like you said, if it is not submitted till the time a resolution plan is approved, so then this will be actually a kind of a dilemma for the SRA.
Exactly. So, this is the problem we as insolvency professionals are facing, that what are we supposed to do if we do not get the claim? How do we, estimate the claim of these departments? We are not supposed to estimate. Now,
Sir, may I ask one small question, sir?
just
I'm
give me 1
Ravi.
second, sir. Just give me 1 second.
Right, sir.
So my only humble submission is that is why I'm insisting that training of the statutory authorities is extremely crucial. They have to understand that either, the law should be so clear that if you don't submit the claim, you lose your right on the claim. Unfortunately, what is happening? They don't file the claim. And ultimately, RPs are responsible for everything and everything. So whatever does not happen, RP is responsible. He has become the scapegoat of the whole process. And ultimately, you find some way or the other to blame the RP. He should have approached the EPF department. He should have got the claim. He should have admitted the claim. So ultimately, if they not filed the claim, then also the RP is responsible. He should have approached the EPF department. he should have, sat on their head and got the claim from the department. That is the stand of the judiciary, unfortunately.
And he should also get the documents right.
And he should have also got the documents from the EPF department. He should have got the claim admitted. Yeah, Doctor, I think Mr. Ravi.
Sir, I'm Ravi Shankar, sir. Sir,
Yeah.
when we approach the PF department, they put the onus on us, RP only, saying that please send me the entire attendance, so basic details
Correct.
and all that, so that I will give the claim. Now they say that they are not able to submit the claim because RP is not able to give the attendance and basic details and all those kind of attendance sheets and all that, sir. So, because most of the RPs are not in a position to give these details because we don't have data.
Sir,
So in
that
fact,
is why,
PF
if you
department
remember,
is in a way reverse.
sir, you
putting
are
onus on
absolutely
the-
right. Every RP has faced this situation. So if you remember in the very beginning, I told you that duties of the directors are not suspended, they are compounded. The RPs must have the power to direct the directors that they go to the EPF department, sit with the EPF department, give the information, get the assessment done, get the claim admitted, assessed. Because what is happening in several cases, I have been the RP, we have instructed the directors that you get the claim admitted or get the claim assessed for the EPF department, give the documents to them. Now, if they don't cooperate, what is the RP supposed to do?
Right, sir. That is the issue I faced. So maybe
So,
you're
so
right, sir.
Nitin ji,
You're right.
I would now request maybe to hand over
Yeah.
to Mr. Sachin Agarwal,
Correct.
and we will continue your presentation maybe afterwards of that.
Yeah,
the
if the
time
time
permits.
permits, I can come in, but I think, let's, I will stop my presentation.
Yeah,
Yes.
yeah. Please sum it up, and maybe we can just hand it over. So may I request Mr. Sachin Agarwal, CA Sachin Agarwal, to share his experiences with the enforcement agencies like maybe CBI, ED, SFIO, in his professional capacity as a forensic auditor and investigator.
Chitkara sir, before Sachin comes in, please allow me to introduce himself. I mean, Sachin.
Yes, please.
So, friends, Sachin Agarwal is a chartered accountant holding certificate in anti-money laundering from ICAI and BSc, and is a certified forensic auditor. He is a partner in Ravi Rajan Company LLP and is into forensics and risk advisory services. He has a rich experience of 18 plus years, and his areas of expertise are forensic audit and investigations, white collar crime defense, digital forensic, financial due diligence, risk advisory, transaction and business advisory, including dispute resolutions. His sector specialization is government, regulatory authorities, law enforcement agencies like CBI, ED, SFIO, etc., capital markets, infrastructure, banking and financial, and manufacturing. He is a visiting faculty at CBI Academy, Ghaziabad, for training of officers on corporate and banking frauds. He has conducted forensic audits of more than 90 cases. He is a member of committee recently formed by CBI for preparation of manual for investigation of bank fraud cases. He is a member of study group formed by ICAI for finalization of forensic accounting and investigation standards. So I request Sachin ji to please join us and deliberate upon his.
Thank you, Parag ji. First of all, I would like to thanks to all office bearer of the IPNet organization, Mr. Chitkara, Ms. Pooja, and yourself as a General Secretary to provide me this platform. And it's an honor to me to sharing the dice with Mr. Honorable former member of the NCLAT, Mr. Srivastava, and a distinguished speaker, Mr. Vikram sir. So basically, my forte is basically into dealing with the investigation cases with the statutory authorities and investigation agencies pan India basis. As a chartered accountant, we always has a hurdle towards the both side of the table as a forensic auditor or as a expert witness or as a assistant to the investigation agencies in various forensic audit related matter or fraud related cases. And when even in the IBC we do the transaction audit and some fraudulent transaction came in, and that report goes to the NCLT and the lenders also file the case. So I am just so first of all, as the Mr. Vikram has already communicated that there are lots of agencies involved when IP become the RP and take over the company as a management of the company. So IP become the RP, and what we understand is the RP is the whole soul in charge of the company after the starting of the CIRP process. So knowledge of domain under which the company operates or the CD operates the very crucial part for the any of the RP a RP to understand the business and various laws applicable to the company. There are so many laws in India, and you never know which laws come to your, parish to the investigation authorities. We will discuss the some cases in which RP was held guilty also together with the CD. So that is very crucial part. And Mr. Srivastava also told about the code of conduct of the RP. So integrity and competence, these two words are very crucial to understand for the RPs whenever we took the case as a RP and become the RP in any of the company. So these are the basically what we understand. Statutory authorities in India like RBI, SEBI, IBBI, IIPCA, EPFO, income tax, GST, and courts. These are our various statutes, various statutory authorities, and enforcement agencies are like CD, ED, CBI, SFIO. Even narcotics also came in one of the case we did. The company was into CD, the company was into insolvency, and some fake import was done by that company of drugs. So NCB came to
Satyajit, 1 second, please. Mr. Parag, can you just share the presentation? I think there is one presentation available.
I am sharing that presentation, sir.
Sir, actually, it is not visible.
It is not visible.
No. So
So
what we see.
आप अपनी screen unshare करिए, मैं करता हूँ.
Just a minute.
Let me share. So this is.
Now it is visible.
Yes, sir.
Okay.
Earlier it was a
So,
fight order.
yeah. So investigation agency plays a very crucial role in maintaining the law or order when the case goes to whenever fraud is declared and fraud is unearthed in the forensic audit, and the in charge of the CD RP filed a complaint with the NCLT avoidance of transaction. In the meanwhile, the simultaneously, generally what the lenders do, they file the case with the enforcement agencies like SFIO, CBI, or ED will came in the picture. Next slide, please. So let us understand how in the IBC process the investigation authorities came into the picture. So this is the basically the process outline when the investigation agency come into the IBC process basically. Whenever we filed as a RP, we filed a case of avoidance of transaction under PUFE under various sections of the IBC. The case goes to NCLT by the RP. Simultaneously, what the lenders do, they file a FIR based on the quantum of the basically the funds to the CBI and EOW. And basis the FIR filed with the CBI or EOW, ED came into the picture and they also filed with the ECIR and take the case. Similarly, in most of the cases where the public interest public interest can listed entities case are there. So whenever a complaint is filed with the MCA order to the ROC for inspection of the company, and ROC upon their inspection order the SFIO to investigate the case. So what we have seen in nowadays, the same case of CD are investigating by the different authorities like CBI also, ED and SFIO also. So that is very challenging task for the RP also to provide all the documentation to various investigating authorities and dealing with the all the investigating authorities and the various statutory authorities simultaneously in the same case. Next slide, please. So this is basically the basically statutory authorities, and these are the few challenges faced by the statutory authority by the RPs while dealing with the statutory authorities. RBI, whenever a case of NBC related company, NBFC company came to the under IBC, so RP have to understand the FEMA related compliances and NBFC related compliances of the RBI. In the same case, whenever there is a listed entity, so the expectation from the RP is that they have to comply with all the SEBI regulation guidelines, SEBI LODR regulation. And the main challenging task for the RPs nowadays is that in case of listed entities, that they have to compliance with all the pending SEBI related compliances before the bidding in the CIRP process, because the CIRP process, the successful bidder will take the company only when all the compliances been done by the RP. So that is the very challenging task nowadays to appoint the company secretary and to get the compounding done from the SEBI and filing all the pending compliances with the SEBI and the ROC. And of course, time-bound compliances under various regulator of the IPs like IBBI and the IYPCA, various timelines are there. So they have to be, comply with all the RPs. So this is particularly the law enforcement agency, as I discussed, ki whenever there is a case is pending with the under investigation with different authorities and RPs get summoned. So as a professional, we did a forensic audit on behalf of the RP under IBC, and we also assist the various authorities like CBI, ED, and SFIO for their investigation. So we know that side of how do they work and what they perceived from the RP and from the forensic auditor. So first of all, while dealing with summons of any notices received from the any of the investigating agency, we need to be very polite, and we need to be very in our communication with those investigation authorities. We have seen in many cases they are asking RP has got the summon, condonation of time with the investigating authority, and bluntly they are saying ki I cannot come on that day, I cannot come on this day, you please give me this time. So this is very we have to be polite, because you never know what is the mindset of the IO or investigation officer who is dealing with the case. These are the various summons or notices being sent by the investigation agencies to the RPs, like submission of documents, books of account of the CD. In most of the cases, what we have seen is RP did not have control over the complete set of books of account or complete things. Basically, document related to a specific transaction required by agency. Whenever there is a forensic report being conducted under IPC, so investigating agency might ask you the specific transaction related documents on the basis of what was declared and this thing. And all the evidences, whenever as a RP, the forensic audit or transaction audit is being conducted, so you have to ensure all the evidence related to the observation mentioned in the forensic audit need to be captured by the forensic auditor in their report. Because what happened in that case, whenever a fraud is filed by the lender with the authority will ask from the RP all to provide all the evidences. Even they ask for the forensic auditor also to provide all the evidences of the mentioning of fraud. If you do not have as a RP, right? If you do not have as a RP all the evidences of fraud related matters mentioned in the report, they will ask you the things, and they will keep troubling RPs also in that case. So the acceptance of forensic audit report is the very, very crucial part in the COC whenever there is a fraud. And all the communication with the CD, sometimes what we have seen, CD is not cooperating, and the RP sent many emails to the CD. So those communication will also part of your things, your documentation whenever there is a notice or someone from the law enforcement agencies. And as a RP, as a CIRP process, RP appoints various professionals like valuers, agencies, forensic auditor, and many other professionals for conducting the CIRP process. So RP must contain all the documentation of those communications also, on what basis they have been appointed. Because what we have seen in valuation of various companies or assets, there was drastically change in the valuation of the inventory, valuation of the assets of the company at the time of investigation by agencies. So ultimately, what they suspect is RP was in collusion with the management. And in my experience, what we have seen in most of the cases, every authority and every investigation agencies have a pre-perceived mind of set ki every professional, even the chartered accountant who did the forensic audit and RPs, all are in collusion with the management, and they are issues with the integrity. So that mindset we have to change. And I always, whenever dealing with these agencies on their side, I always say कि CBI is also investigating the CBI, ED is also investigating the CBI, CBI is also investigating the ED. So every profession have the black sheep, and you cannot, let the say कि all professionals are like that only. So we will discuss 2 or 3 cases, practical cases. right? And a crucial part of that, ki whatever decision being taken, you as a RP in any of the COC meeting, keep the minutes of meeting very handy, and every aspect of decision taken by the COC and every lender in that minutes of meeting. Sometimes what we have seen, ki many of the crucial part of the discussion or crucial decisions was not captured in the minutes of meeting by the RP. So ultimately, whenever cases with any of the investigating agencies, they churn the RP for not capturing that decision in the minutes of meeting, because ultimately COC has to decide whatever decision they have been taken. Since we have seen in many of the cases, the ultimate value realization of the companies and haircut being given by the lenders. So in that sense, the decision taken by the lenders for the haircut, that has to be, uh, clearly captured ki why this proposal been accepted by the COC on 90% haircut or 80% haircut. Because nowadays what we have experienced, law enforcement agencies, typically into case of ED and CBI, they are also investigating matter with the fraud with the CD and this aspect also. Why this haircut been given by the, because ultimately when the FIR been filed by the lenders, so they named the anonymous public servant also. So whenever there is a haircut in any company, 80%, 90%, though they behind those public servant also of the lenders, like banks, officials and all, why there has been a haircut of so much of amount, and they have their mindset ki RP is also, hand in gloves with the COC or promoters and all are being party of that process actually. So we have to be very careful while drafting the minutes of the meeting. And this is and one more part is that the detail of assets in control should be in with the RP. What we have seen in one of the cases, I'll discuss a case where asset was not taken by the control of the RP. Might be, matlab, what I think, but the ultimately that RP was being accused, made accused by the CBI in that case along with the CD, because they have hide the assets of the company as a whole. So we'll discuss that case. And knowledge of various laws as applicable on the domain of the company which we have become the RP is very, very crucial. What we have seen in many of the cases, as a RP, we should have the knowledge of the Transfer of Property Act is the most part of very, very crucial. Because sometimes, there is a asset in the company, hard asset in the company, and some agreement being done by the CD before the CIRP, some agreement to sale, and Partnership Act and Sales of Goods Acts. Next slide, please. So these are the various pointer we have mentioned for, based on our understanding and working with the, regulatory and enforcement agencies. Legal and regulatory complexities are there, as mentioned by the Vikram sir and the Mr. Shivastav sir. There are frequent regulatory changes in all the laws like Companies Act, SEBI Act, RBI Act, and even in the Insolvency Act. And conflict between insolvency laws and other statutes is always there. That create uncertainty towards the compliances that become the challenges for the RP. Coordination with multiple authorities, as I mentioned, we as a RP, we have to be, we now into the management of the CD. So we have to manage and dealing with the multiple authorities on the domain of the company, of the business of the company. Next slide, please. So that also, whenever there is a case persisting in any of the court or any of the agency or statutory authorities, so that delays in investigation and asset recovery part of the most crucial thing. And RP is not able to, decide the CIRP process resolution plan or liquidation of the asset. Enforcement of orders and judgments, so also a bigger challenge for the RP in dealing with the court orders and the summons or notices being given by the various law enforcement agencies and statutory authorities. Next slide, please. Next slide, please. So, one basic aspect we need to understand as a professional, or as a RP also, whenever we conduct a transaction audit or forensic audit under IBC, so we can comment on the fraudulent aspect of the transactions, not allege the promoter of the company as a fraud, because in every statute we have in India for the law enforcement agency, the intent to be the clear for doing a fraud. So whenever is a case filed with the CBI, SFIO or ED, so their main key thing is that we need to prove the mens rea. Mens rea is the criminal mind. Whatever transaction being done, which is mentioned in the forensic audit report or transaction audit report and filed as a avoidance of transaction by RP in the NCLT, right? That should be clear, evident with the transaction, and mens rea should be there. But as a person, we cannot, comment on the mens rea part of the promoter of the company. So their always intent is there ki forensic audit and transaction audit not done up to the mark, and they will chunk the forensic auditor and RP also in most of the cases. That leads to challenges of establishing fraud in the court of law. Next slide, please. So this is some common responsibilities across agencies and authorities of the RP, custodian of the corporate debtor assets, ensure compliances with legal and regulatory requirement, protects stakeholder interest, conducts audit to detect fraudulent transaction, transparency, stakeholder protection, reporting to NCLT. Next, cooperation and assistance, reporting suspicious activities, avoidance transaction. In August 2020, IBBI has floated red flags about the CD, if there are any red flag. So what nowadays investigating authorities are doing, they are asking the RP ki where is the file of this compliance of this red flag. I do not know how many of you as a RP doing that exercise, but my suggestion is that avoidance of transaction, the red flag issued by the IBBI, that should be prepared and preserved with you, so that whenever there is a notice or summons come from the any of the investigating authorities, you get the things done at their ease, because they expect whatever compliance being done, that should be done by the RP only. So they may ask that red flag checking, whether those red flag checking being done by the RP or not, right? Or it is the mindset of the IO, every time they see RP is always collusion with the management. So now it is the onus to RP. They have to prove that they are not in the collusion with the management, and they did a fair job with the integrity and competence with the IBC law. Next. Whenever there is a case with the ED, so ED, it conflicting with the attachment of assets under PMLA, or in that part, the CRP is hindered by the various enforcement agency. Case studies, please. So I will not here, I have mentioned few of the cases. I will not name any of the company name or any of the RP name and forensic auditor name, but I will try to highlight the issue of the cases. So this is the case which we have done as a forensic auditor also, and we assist the CBI in this case also actually. So this was the case of a setting of a power plant of 1000 crore that was financed by some lender, and collateral security was there were two land in the company. The ground of the case was there were two land in the company. One is the phase 1 land and one is the phase 2 land. So collateral security was given to the lender against 1000 crore was the phase 1 land, which was valued at around 1200 crore. And during 6 years of time after the sanctioning of loan, CD has incurred a cost of around 1300 crore, including the promoter contribution. But the project was halted due to some protest by the environmental NGO. CIP was initiated and forensic auditor appointed. So in that case, what the RP has done, forensic auditor was appointed limited to phase 1 only, not the entire affairs of the company or CD, because the loan was given for the phase 1 land, phase 1 project, and the collateral security was earmarked to the phase 1 land only. So forensic auditor specific was asked in their scope of work to do the forensic audit of phase 1 only. We do not know they have deliberate left out the entire affairs of the company or phase 2, phase 2 of the company basically. So we as a forensic auditor unearthed that during the forensic audit, phase 2 land, which was market value of around 800 crore, that was under litigation by executing a agreement to sell by the CD during the CIRP process. And when the case was filed with the CBI, so RP was saying I was not aware of it when this agreement was executed. So the point I am trying to making is that here is that whenever you become a RP of any of the company or any of the CD, so you have to conduct the forensic audit of the entire affairs of the company, whether pertain to your loan funds or not, right? Because what CBI has done in that case, because forensic audit scope was specifically mentioned, you need to conduct the forensic audit of phase 1, and the report was accepted by the lenders also, but ultimately lender filed a case with the CBI. And when they got to know, and after that, they've been accused the RP also in that case. They have not told us that this land, phase 2 land, was already between the agreement to sell by the CD with their connected party. And a claim was filed by that company with the IP in that case, with the RP. And RP did not check, I don't know, deliberately or, by ignorance, did not check who is this party who filed a claim on that land actually. So first case was filed with the CBI for the CD, and after the discussion in the meeting with the joint lender meeting, case was also filed with the IP in that case. And now the case status is that the charge sheet was filed with the court by the CBI for the RP and CD both actually. So this is the very crucial. This is the case 2, is the fabric manufacturing company, or there was loan of working capital limit around 1,000 crore. And there was debtor outstanding of more than 500 crore from Dubai-based customers. So this forensic audit not done by us, but we assist the CBI in that case. The FIR was filed against the company, but anyhow, while doing the investigation, IO got suspected that the promoters bought back the company in the CIRP in collusion with the RP. So when we did the investigation, so we got the things that RP has formed a company in Dubai with his son name and bidding in the CIRP process. And eventually they got the company on haircut of 80%. So RP also framed in this case by the CBI deliberately on a quid pro quo basis, even though he was not, mentioned as a accused in the FIR filed by the banks. So again, the integrity part has to be there and should not be done these things. And this is the one of the real estate company, or this was also conducted the investigation under IBC. There was general purpose corporate loan, and this loan was, backed by the collateral security of the listed shares of the holding company. And that loan was diverted to some buying of the coal mines in Zambia and some other country, and avoidance of a transaction application filed with NCLT, and charge sheet was also filed with the court under IPC and PMLA. And this case was also, so I am making the closing remarks here. How much time I will have now?
Sir, you have to make it fast. You have to sum it up now, please.
Okay. So I am just try to conclude and just to make it concluding remarks that whenever we are dealing with any of the investigating authorities and the statutory authorities, we need to have our documentation very complete in all respect, and we need to be very polite and need to know basis to be answered to all those agencies. Thank you.
Now, I would request Mr. Singhal, Parag Singhal, to express Thanks to our speaker, Mr. Sachin Agarwal.
Thank you, Sachin, for deliberating on the topic and sharing your vast experience in the field of investigation and fraud and investigation with these enforcement agencies. And what I could learn out of this deliberation is that over and above the problems that we as RP face, most important is our integrity, our honesty, our competence, as well as our maintenance of proper record, which is mandatory if we face those authorities, right?
Definitely.
So thank you very much for sharing your experience and taking out time. I know you came directly from this meeting, which is being held by Institute of Chartered Accountants in Dwarka, and he rushed from there to his home or his office to attend this meeting. So please allow me to present a memento to both our speakers before we move forward. Just a
Yes,
moment.
sir, yes.
Just a moment. Vikramji, thank you very much for joining us and being a valuable part of IPNet. All know that you are heading IP North till date, and now you are here as a keynote speaker. Congratulations to you and thank you very much.
So maybe we can have some more minutes from Mr. Vikram if time permits. So,
Yeah, just a moment. And
yes.
Sachin, thank you very much for joining us. This is a token of appreciation for your time
Thank
and
you.
experience. And these
Thank you, Paragji. Thank you.
these mementos will be physically delivered to your office. And now, as Mr. Chitkara said, Vikramji, we have another 10 minutes if you can join again for your deliberation. Please unmute yourself.
So you want me to have a Q&A or start with the presentation?
Chitkara sir, we can have Q&A.
Yeah, I think we can go ahead with Q&A, and if lastly, if time permits, then we can have maybe another interaction with Mr. Vikram.
Yeah, Tina, can you join in?
Yes, I'm already
Yeah,
there,
yeah,
sir.
I would
Visible to
request,
everyone, I believe.
Yeah,
yeah.
please take some
I would
questions.
request Tina ji to moderate this session.
Yeah,
Yes,
please
yes.
take questions from question and answer this chat.
Yes, 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 sir. Thank you, Chitkara ji, Parag ji. There is a question here from Hari Prasad ji. Are you there, sir? What an RP liquidator should do when summons are issued for personal appearance by ED or CBI?
Sachin, can you answer that?
Sachin ji, question for you.
Yeah, so as I told, whenever there is a summon or notice for personal appearance by ED or CBI, so don't ignore it, and just ask them to meet him and discuss the things, because you are a professional and appointed by the court. You are not a layman. You are driven by the process and appointed by court. You need not to be worried about any of the questions they would ask. And as I told, you need to have all the documentation records as per the IBC law in compliance with the various laws proper, and you must go there with a clear and calm mind. So don't try to avoid them, and be polite and answer only need to know basis.
Sachin, tell me one more thing. In case somebody gets summoned from ED or CBI as RP or liquidator, is it really required to take legal help?
Not really, sir. Because first of all, as I told, you must go there and visit there, and you are a person appointed by the court, right? So you need not to take legal help at the first junction. But in case you feel you need any legal help, because they cannot do you anything unless you have done integrity issues, right? So you need to have proper in the records and the minutes of the meetings. So that is the most crucial part of it.
Thank you, Sachin.
Sir, one thing, more clarity to this. If we get issued for personal appearance, can we take the person from the CD or a responsible person who can give reply?
No,
Sachin
no,
ji?
sir. No, ma'am. No.
They don't allow anyone to access the premise.
Not at all, actually. Whenever there is a notice come to in your name, so you must go there and you must visit them and be polite, take your time. If you have not ready with the documents, just to go on the same date and ask them to give you for more time, and they will entertain it.
Okay, okay.
But
Thank
don't ignore them.
Okay, sir. Ravi Shankar ji is there who has raised his hand. So we'll take from there. Then one by one we'll take.
So kindly
Ravi Shankar
unmute,
ji?
sir. Ravi Shankar, sir. So kindly unmute.
Yes, please unmute. Okay. Now.
Sir, no, madam, now I think it's
Yeah.
Yes, sir.
able to-
Audible,
okay.
audible. Please proceed.
Madam, see, actually, though my question is not pertaining to the compliances by RP to the various agencies, we are being asked by several RAs and while selling in going concern also, whether these income tax authorities are not permitting them for carry forward losses is one thing. And also when the sale or going concern happens, the reduction in the liabilities is being taken by them as a income. So this is a post sale, but is not an RP problem, but if it can be taken up, how to convince these RAs and persons have been bidders appearing as a going concern, how to convince them that income tax is not a problem for them, because after bidding for say 10% or 20% of the value, and 80% if they're getting this one, that can be answered.
Ravi Shankar, sir, we have a question answers column in our IPNet site also.
Okay.
Please go to that, put in your question, and we'll certainly reply back on that.
Okay.
Yes,
Sure,
sir.
sir.
It will be
Thank you.
helpful
Thank
for
you.
all of us.
Thank you, sir. Thank you. I'll definitely do that.
Yes, sir.
Thank
Today
you.
we have a different topic. So, will transaction audit not only help substantiating the fraudulence consideration of CD, or forensic audit is must for substantiating fraud?
Sachin, they
Mr.
are asking
Shilajit
if-
here.
So transaction audit itself cover the section 666 of transaction. So that would cover the fraudulent transaction. So nowadays, transaction audit, come forensic audit is being, appointed by the RPs in most of the cases. So ultimately, forensic audit and transaction audit is the same thing, basically.
Okay. Any questions?
So this forum is open for members to ask questions, please.
The ED, if they call for the MD of the company CD, I think RP has to attend, even though there might not be a direct notice to the RP.
Sir, to answer to your question, whenever a summon is issued against the MD of the CD, RP did not go actually. Unless it is the named you actually as a RP.
So, sir, what I understand, Sachin, from your point is, the person in whose name someone is issued should only go.
Correct.
Right.
And they issue someone with a proper name and everything. Correct, sir?
Correct.
Okay. Any other question anyone wants to ask?
Good evening. Good evening. My name is Bhuvaneshwari. I have one question. See, I am running one CIRP where it's an AD attached properties we are having. And we filed application in NCLT for de-attachment of the properties. And I'm sure once the resolution plan is submitted, de-attachment by NCLT is possible. In the meantime, I'm sorry for my throat. I have some health problem.
No,
Yeah.
ma'am, you are
So-
audible properly. Please continue.
You're audible.
So in the meantime, my creditors, the lead banker was called by ED last week, and they said that you file an application under the PMLA, and we will allow you to sell all the assets and distribute it amongst yourselves. So this is what the ED has told. Though they have filed objection to my application in NCLT, they have told the banker. And the banker informed me saying that, madam, please call for a meeting and all that. Anyway, I'll be calling for a meeting. So in the meantime, I would like to get your views on this. Of course, I have formed my views on this because IBC is supreme and it is under CIRP. So nobody else can do anything. But I would like to get your views.
let me take this question.
Yeah, sure.
Sure, sir. Sure, sir.
So actually, I have not been able to cover my presentation on the PMLA, but your query is very pertinent. So we as RPs basically face two kinds of attachment from ED. One is a provisional attachment and one is a final attachment. So these are the two attachments which we face during the CRP process. Now what happens? The general, again I would use a term mistake, which RPs normally do, is for every problem we go to the NCLT. So if there is an attachment, we think it is a violation of the moratorium provision, and we file our application under before the NCLT, requesting the court to pass orders for detachment. Now let me tell you here, if you read most of the judgments, now this stands absolutely clear without any iota of doubt. NCLT has no powers to direct the PMLA authority, that is the ED, to detach the assets. So the understanding, which is very, very important, is NCLTs under section 60 subclause 5 does not possess the powers to direct PMLA authorities to detach, because moratorium does not apply to the attachment of PMLA. So this is important to understand, that attachment by PMLA, moratorium is not attracted, because the provisions of PMLA are not against the company. It is against the directors of the company. All the prosecution, all consequences is against the directors, and directors cannot have any benefit of moratorium by the PMLA. So you have to approach the adjudicating authority under the PMLA Act for the detachment if you want a detachment. So this is the first step which every RP needs to understand, that NCLT is not the forum for the relief which you are seeking. The second point is, what you can get the relief is, you will only get the relief under 32A. So what happens, once a plan is approved, then NCLT can direct the PMLA authorities. If the SRA has no connection with the promoters of the company, then NCLT at that stage, after the plans have been approved by the NCLT, those assets have to be detached by the PMLA authority. So what is important to understand is, if you want the process to run smoothly without any attachment by the PMLA, approach the PMLA authorities, follow the process under the PMLA Act, get the detachment from the adjudicating authority under PMLA. Or you can only approach the NCLT under 32A, which relief you will get only when your plan is approved, not before that. So what actually happens, if your assets are under attachment, it actually diminishes the value of the resolution plan. Because what happens, the SRAs will not give you the desired value which you would otherwise have received if the assets were not attached. So, this is a dilemma, that you wanna go to the PMLA, get the attachment removed, run a successful process, or, you go to the NCLT, but NCLT is not the panacea for all the problems. So that is the point I'm trying to make here.
There is
Good,
one
good, good, Vikram,
question.
good. So can I ask one question?
Yeah, please.
So, Mr. Vikram, in one of my cases, actually, asset is in custody of EOW under the MPID Act.
Okay.
So what is to be done in that very case? So what do you think about it?
So, if the attachment is on account of all this money laundering, the issues pertaining to money laundering.
This is about the public deposits. Actually, some fraud is there committed with respect to public deposits, and as per the MPID Act, so the court there has put the assets under custody of EOW.
Okay. So I think, in this case, again, the challenge would be, maybe, you would be able to get hold of the assets of the properties once you get a plan approved. But, I'm not very sure whether, NCLTs can direct these authorities to, remove the attachment. Because if you read the judgments pertaining to PMLA, then the courts are very clear that PMLA and IBC can harmoniously coexist. So what is important is 238, if you read section 238, the important part of 238 is that IBC will override if there is anything inconsistent. Now, is every act inconsistent with IBC code? So the court, the law, the judiciary have normally interpreted that IBC can harmoniously coexist with the other acts, and IBC will not always override the other acts. So, but basically, once a plan is approved, then I believe that the SRA must get control over the assets, but may not be possible before that.
Actually, thing is, Vikramji, thing is that PMLA is actually this comprises criminal money. So what I think is that this is about criminal money, but I'm talking about a fact wherein financial fraud is there. So wherein assets are put under custody of.
So Sandeep, fraud has an element of crime. criminal intent, basically. So from that perspective, I'm saying, because if you see money laundering is again proceeds of crime. So I think, they could be on similar footing. They could be, I'm not very sure, but I think they could be on a similar footing.
Mr. Ghosh has some question. Mr. Ghosh?
Mr. Subrata Ghosh, please. Unmute yourself, sir. Okay. We have a question from Mr. Srinivas.
Namaskaram, sir. Am I audible, sir?
Yeah, yeah.
Yes,
Please.
sir.
Audible, sir.
Sir, in my case, NCLT has given in section 66 petition, there is a prima facie evidence to file a case with ED. You submit this order to ED to register a case. I have submitted NCLT order to the ED. They are not taking any action. Shall I have to go to CBI and register FIR, sir, first?
I think, let me come in here. So, Mr. Srinivas, if I remember correctly, there are orders, of the NCLT, which very categorically says that NCLT does not have the power to refer the matter to ED. So, there is a separate process laid down for referring the matter to ED. NCLTs are not empowered to refer the matter directly to ED.
And I would like to add, sir, I would like to add here with
They have said, sir, there is a prima facie evidence to register a case with ED.
Sir, so, Mr. Srinivas, yeah, sir, I think Sachin wants to add something.
Yeah, sir, please, sir. So thanks, sir. So what I will suggest to you, sir, if the NCLT has ordered to file a case with the ED, prima facie evidence of fraudulent transaction, so in that case, lenders in that case may file a case FIR with the CBI, and on the basis of that FIR, ECIR may be filed by the ED. Then ED can take the case.
Sir, as a liquidator,
sir, ED can take the case only when there is a prior FIR. If there is no FIR, as the Vikram sir has already put in, NCLT has no jurisdiction over ED to file a case actually.
Sachin.
Okay, thank you, sir. Thank you.
Sachin, I have a question on your answer. Can anybody file a direct? Can anybody file a direct complaint with the CBI?
Yes, sir.
I don't think. There are jurisdictional problems out there. We cannot simply go and file an application with the CBI.
Sir, you can complain if there is a public money involved in any of the case, you can file a case.
As per NCLT, if NCLT found fit, NCLT has to direct MCA that there is a problem like this, take it for further. Then MCA has to approach, let me complete. Then NCLT has to approach central government, and central government will direct either CBI or forensic, this one, FT, to investigate further. This is the procedure of NCLT. NCLT can give back it to MCA. MCA will refer it to central government what to do, my dear central government. Then central government will decide to where it is investigated. Because no one can investigate a company unless otherwise CG approved. So this is the process. And another thing, I am sitting in Tamil Nadu. I cannot approach a CBI to investigate something. Because CBI is not having a jurisdiction to investigate a case in my state because of the jurisdictional issue. So it is allotted with the permission of the state to investigate this matter by the CBI. So this is the procedure situation. So in the question what it is raised by the gentleman, I think there is an issue. If NCLT feel there is a
prima facie evidence,
then NCLT has to refer it to MCA. This is what I know from the Companies Act. This is what I know from.
No, sir. This order,
Mr. Vinod, you are.
Sir, this order directly goes to MCA, sir. MCA is silently sitting. It is not taking any action on its own.
Let me come in that sense,
Sir,
Mr. Vinod.
Again, I cannot go to MCA.
Yeah,
sir, I cannot go to MCA.
Sir, I am in agree with your point. NCLT can direct MCA, MCA can direct central government, and
MCA will not direct. MCA will take opinion. This is the situation. Then CG will take a call to investigate or not to investigate. If at all investigate, is it by CBI? Is it by this one Intelligence Bureau, or it is by serious fraud investigation team? So this allotment is happened by the CG and not by any other department.
CG, which
Sir,
department we
I
have
have
to go,
seen,
sir?
sir, I have seen in many of the cases with my
I don't know.
experience.
This is what this companies are talk about investigation, inquiry investigation chapter.
Sir,
If
I
I am
have
correct.
seen from my experience, I can tell you, sir, I have seen many of the cases where CBI is directed by the
Maybe
state government.
I'm not an expert in Companies Act, but I tell you.
Vinod,
I just clarify you, sir. I just clarify you.
Just hold on, please. Just
Let
hold on.
Mr.
Just
Sachin
hold
make his
on.
point. Yeah.
Just
Yes,
hold on.
Mr.
Just
Sachin.
hold on. What I'm
But I
requesting
think
is,
the lenders can always file a complaint with CBI. So that lenders can always do.
Because the problem, CBI cannot take a public litigation.
I think this matter will require a lot of debate, and a next new
Yes, yes,
webinar
yes.
on this matter
Yeah.
may be conducted. So
Yeah. The
Mr.
problem,
Ghosh is
Tara, you
waiting.
cannot direct
Yes,
approach
yes.
CBI
May I ask the
without
question,
your
please?
state permission. Punjab has to give
Sir, may I
permission.
ask the question, please? If you
And,
can
yes,
permit.
Mr. Ghosh.
Actually, I have two questions. One is regarding PF. Another one is regarding a forensic audit or a non-cooperation of SBOD. First, I'm asking for the question of PF. PF department has raised three demand, but they have not shown any of the supporting document. One is 40,000 something, another is 63,000 lakhs, another one is approximately like that. But then I asked them which one is correct, and give me supporting or give me form in supporting form. You please submit me so that I can consider. Like affidavit must be there, but officials are not doing the same thing. One assistant commissioner only given 40,000 claim. OB, that is also not related to employer's due. That is related to only the penalty.
Yes.
Another one is giving a demand notice supporting 5-6 years back, and company last accounting balance I have received 2015. After this, nothing is there. Company is right now liquidation. After writing to them that give me in a proper form, they have not replied anything. What to do now?
Sir, similar things. I think Mr. Vikram Kumar will answer. So similar thing is happening in many of the cases. Sir, you have rightly pointed out a very correct thing which we all are facing. That is a real problem of all the RPs. Like what we are getting, the claims we are getting, and companies are already closed from the last 5-6 years. Am I correct, Ghosh, sir? That's what you want to say? And
Yes,
now
yes,
they are
9
just
years, no document, no data.
now they are submitting a penalty and all these details, and now no data, no detail of the employees, right?
Right. And they are saying they do not have anything. Employees claim or nothing.
Then how
I'm
they will
then
pay
why
off?
you are asking money? Then why you're, well, they said it is a previous claim. I mean, how can you establish me? Then only I can give, or give me at least affidavit that you are telling is truth.
Sir, in
They are not giving. So I have
True,
not
sir.
till now, I have not admitted any claim, only put in the SCC that this has been a claim, but I am not able to justify
So,
this
Mr.
claim.
Ghosh, let me come in here regarding your query. So
Yes,
what
sir.
you have raised is fine. You have to understand that you as an RP is the sole authority to admit any claim, right? Nobody can direct you any claim to
Now
be
I am a
admitted.
liquidator, not as a RP.
Okay.
Because that
So
party,
when you are a
CRP is over.
liquidator, then as a liquidator, you are the authority to admit the claim. Now you
Right.
have all the right to ask relevant questions for admitting claim. But please remember, whether it is CIRP or liquidation, if there is any claim of any statutory authorities, and even if you have not admitted, the process of adjudication or admission is going on, please record it in the information memorandum if it is in CIRP, stating that this is the claim received, contingent not admitted. At least the information for a claim received by you for a statutory authority must be communicated to all the prospective resolution applicants, because EPF claim specifically has a very serious implication on the resolution process of a company. So
Right,
if
sir.
you have not
Resolution,
admitted,
Sir, just a minute, because here the resolution applicability is not applicable because that is nothing has happened. That's why it goes to the liquidation. Now only question of selling the asset and whether we'll entertain their claim or not, that is the question comes.
So that is for the court to decide. That
Right.
adjudication will happen by the court, because if you don't admit the claim, you take it for me that the EPF department will file an application against you in the court, and finally the court will decide what is the claim to be admitted. And normally I have seen EPF claims means it has to be paid in priority to all the assets of the company. So you have to be very sensitive to this issue, is all I'm trying to say. We will not drag this
Right.
issue too much. So you have to
Right,
be
sir.
sensitive. If you don't admit the claim, file an application in the NCLT, let the NCLT decide, but resolve this issue, don't keep it pending.
Okay, your advice is to file a application to the NCLT and saying that two claims has come and two different, one is 40,000, another is
So
60
that
lakh.
could be one of the solutions that
Correct,
resolve
sir.
this issue
Okay,
ASAP.
I am asking for the solution only. I am
Yeah.
not going for any debate. And your advice is always helpful because it is a collective advice.
But
and,
sir, this is not a legal advice. Please take legal
It has to
advice.
be concluded
Oh,
now.
okay, you said it is going to NCLT. That's the
We are
one
just,
advice. So,
we are just discussing.
right, sir. Another one is that is also in liquidation. That in
We
CRP,
have to conclude now.
there is a non-cooperation for the SBOD. Till it is non-cooperation going on, and they have not handed over the asset to the earlier erstwhile RP until to the liquidator to me. So we have complained to the NCLT and fighting against each other. They have NCLT given a summon and called the person. Now there is some because they have sold entire stock and other thing during this
Sir,
3-4
what is
years.
the question, sir? What is the question?
Now, done now. My
Yeah,
specific question
please
is that
be specific,
how
sir.
do
We
I
are running
do
short
this?
of time.
Fraudulent application is applicable here. If I got a sum without any asset, suppose stock is not there, cash is not there,
So
other valuable
in
asset.
liquidation, all the
In
fraudulent
liquidation.
provisions are applicable. Buffet transactions are applicable in liquidation also. So
But
if you
how
think
can I
that
prove
the
until I got the handover and documentation, because document is not available. All document is along with the CD only. SBOD means
Right.
that is.
I think, Vikram sir, it will
Sir,
require a personal discussion in detail, I believe,
Sir,
because
I,
prima
Yes, yes,
facie
yes.
I think
wrong,
let us
That's the
conclude,
problem.
let us conclude this way.
some wrong
This will
suggestion may
require a
go
full-fledged
prima
This is
facie.
webinar.
the solution.
Ghosh sir, it requires a detailed discussion because prima facie
Right.
solution may not be good for you, I believe. And
No,
everyone
there
will
is a
agree with
solution.
that
I know
because,
there is
yeah.
a fraudulent
So,
activity.
Tina ji, let us
And I
conclude
have to
this.
do, but
Let
how
us
can I
conclude
prove
this session.
without document?
Yes, yes, sir.
Because they are not handed over. You cannot say there is a change in, and last balance sheet is
Sir,
2021.
Goshav, you can post your query on IPNet website. We will answer that. Moreover, your query is not related to the discussion that we are holding on the topic. Please bear with us. We are
Because you are stating that, transaction audit and forensic audit, that's why
you
it is
are right,
related.
but
I thought it is related, that's why I asked.
you can write the question there and we'll all be benefited out of
Yes,
it.
yes, sir. Facts will be
Yes, sir.
actually
All,
analyzed on the
definitely
basis
there
of
is a
written
real situation.
statement in
Yeah.
much
Yes,
better way, I believe.
yes, sir.
And,
Yes,
and before moving
thank you,
forward,
Mr.
thank
Ms.
you.
Pandey and Mr. Singhal, and also
Okay, okay.
Thank you, Ghosh sir. Please do post your query so that we all be aware of the actual facts and we also will have some discussions over there. Thank you.
Okay, now I would request IP Pooja Bhari to conclude, maybe to provide a vote of thanks.
Good evening, everyone. I'm IP Pooja Bali. I'm representing the IPNet North, and it is my privilege to extend the vote of thanks for today. I'd like to express my sincere gratitude to IPNet for providing me with this opportunity. Now, today's event was much more than a webinar. It actually felt like the start of something truly significant, a movement that will shape our professional community in the years ahead. First and foremost, I extend my heartfelt thanks to our honorable chief guest, Dr. Alok Shirvastav, former member of Technical NCLAT. Sir, your presence has added immense value to this occasion. Sir's insightful words and vision have inspired all of us to think bigger and strive for excellence. And thank you for gracing us with your time and wisdom. I'd also like to thank our president, Mr. Ashik Makija sir, for his relentless dedication and visionary leadership. That is what continues to make IPNet a platform of unparalleled importance. A special note of goes to the lead speakers of this webinar, IP Mr. Vikram Kumar and CA Mr. Sachin Agarwal, and our dedicated coordinator IP Mr. Sandeep Chitkara and Mr. Parag Singhal. Your valuable insights and perspectives have enriched today's discussions, offering us a new direction and understanding which will surely shape our future work. Thank you for your commitment and for sharing your vast knowledge with us. I would also like to extend my sincere appreciation to Transition and the technical support teams. They work tirelessly behind the scenes, ensuring that everything runs smoothly. Your hard work is the foundation of successful events like this one. Thank you for your unwavering support and flawless execution. Finally,
And
to
now,
everyone who
yes.
participated today, your presence, enthusiasm, and active engagement have made this event truly remarkable. Together, we are building a community that will not only foster professional growth, but also derive innovation and collaboration in the insolvency profession across India. Thank you once again to all those who contributed, participated, and supported this remarkable initiative. This is only the beginning, and I look forward to what we can achieve together in the future. Thank you.
Thank you, Pooja-ji. Now I would request my colleague, executive member, IP Net East, to make announcement of the next webinar.